Hello, everybody. I wanted to come on and do a live discussing California's or rather, California's nonprofit religious corporation law, and how it relates to corporate Scientology, and how we can maybe leverage this knowledge to bring about some positive change. I'm not licensed to practice law in California, so these are lay opinions, and I haven't exhaustively checked every detail. This is going to be pretty dry and boring. But hopefully someone will find some of it interesting or useful. And when I initially set out to do this, I'm going to be reading mostly from notes. I imagined I'd be starting with a detailed overview of the history of Scientology's legal structure, and particularly the corporate sort out that they undertook in the early 1980s, before going into a line-by-line breakdown of the applicable provisions in the California Corporations Code. But that was a bit too ambitious. The corporate sort out is super complicated, and there's already a lot of great stuff out there about that. So I'm not going to do that. I would recommend anyone who's interested in that check out some writings from the late Denise Brennan, who was deeply involved in the corporate sort out and who wrote about it pretty extensively. And in particular, there's a declaration that she wrote, a sworn declaration that's available on Lermanet. So if you just search like Lermanet Scientology Brennan Declaration, that'll come up, and that kind of lays out everything in more excruciating detail than I could hope to provide. So for our purposes, it's worth noting that the Religious Technology Center, the Church of Scientology International, and the Church of Spiritual Technology are all, and at all relevant times, have been incorporated as nonprofit religious corporations in the state of California. That means they're governed by California's nonprofit religious corporation law, which is at CalCorp Code Section 9110 et sec. And as we'll see, the law grants Scientology favorable treatment in many respects, even relative to other California nonprofit corporations, which do not have an ostensible religious purpose, or which, for whatever reason, are not incorporated under the auspices of the California Nonprofit Religious Corporation Law. One could argue that the California Nonprofit Religious Corporation Law is essentially a set of codified loopholes that allow Scientology and probably other similar organizations to avoid basic oversight from the California Attorney General's office and from the public, and which make it easier for the highest echelons of this global criminal enterprise to operate in a state of opacity and occlusion. Hey, Heather Mack, how you doing? I'm going to refer to a couple of documents provided by the Napa Legal Institute, and I'll maybe provide links to them in the comments or something, but you can just Google it. On the Napa Legal Institute's website, they describe themselves as an organization that, quote, educates faith-based nonprofit leaders on general corporate and legal issues, end quote. And as best I can tell, the Napa Legal Institute is basically a conservative Catholic legal think tank based in Washington, D.C. So they're like kind of in favor of these, what I'm calling legal loopholes, they would call protections. And they write about this stuff extensively. And, it's from the perspective of someone who's in favor of all this. But they're a real outfit. They have like good lawyers, and they're a lot of money, and they know what they're doing, and they know what they're talking about. So there's one page on the Napa Legal Institute's website that ranks the religious corporation laws in all 50 states, and it divides them into 4 tiers, with 4 being the lowest and 1 being the highest, from the perspective of this conservative Catholic legal organization that provides resources to religious groups, religious nonprofits. There's 29 states in the 4th tier. And presumably that tier also includes most of the states that don't have specific provisions for nonprofit religious corporations in their corporate code. Tier 3 includes 6 states, and Tier 2 includes 15 states. And in Tier 1, there is only 1 state So, head and shoulders above everyone else in its own category is the state of California. So, there's this conservative legal group, religious legal group, that acts as a kind of consultant or a think tank for faith based nonprofits all over the country. And they think that California law provides the most protection to these organizations, more than any state in the union. And this is the law that governs RTC, CSI, and CST. Then, in another page on the Napa Legal Institute's website, their president and general counsel, at least he was president and general counsel at the time he wrote this, John C. Pfeiffer II, provides a non-exhaustive list of those protections, which I'll read from and refer to. So the first one that he notes is 1, for nonprofit religious corporations, transactions involving conflicts of interest and self-dealing may consider whether such transactions are just and reasonable to the corporation, taking into account the organization's religious purpose, or whether such transactions further the organization's religious purposes. And there's a footnote at the end of that paragraph, and the footnote reads, see CalCorp sections 9243 and 9244 for the standards applicable to nonprofit religious corporations. Contrast these standards to those applicable to nonprofit public benefit corporations set forth in 5233 and 5234. And a nonprofit public benefit corporation is basically a regular nonprofit. Okay, so let's do that. Let's look at those sections. And I apologize, I don't know how to screen share and stuff. It's easier to do that. It's easier to follow all this if you're like looking at it, but I just want to like put this on the record. Okay, so section 9243 of the California Corporation Code, which is part of the nonprofit religious corporation law that we're talking about, reads as follows. Except as provided in subdivision B for the purpose of this section, a self-dealing transaction means a transaction to which the corporation is a party and in which one or more of its directors has a material financial interest and which does not meet the requirements of paragraph 1, 2, 3, or 4 of subdivision D. Such a director is an interested director for the purpose of this section. And then it provides, and then in subsection B, it says this section does not apply to any of the following, and it gives some examples of things that don't count as self-dealing transactions. And it gives a whole long, it's a whole long complicated statute. But, you know, like the interesting part, I guess, is that, you know, it whether the transaction was in furtherance of the corporation's religious purposes is something that the board can take into consideration in determining whether it's self-dealing, which is interesting to note. Yeah, and the analogous provision for public benefit corporations is very similar, but it doesn't have that that thing about, you know, whether it just has to be reasonable under the circumstances. It's not reasonable under the circumstances or in furtherance of the organization's religious objectives. Okay, now returning to the Napa Legal Institute's white paper and the list of advantages for organizations incorporated under California's religious nonprofit corporation law. 2, so their second point says directors of nonprofit religious corporations must act in good faith in a manner believed to be in the best interest of the corporation and with the care appropriate under the circumstances, but the directors may rely on reliable and competent religious authorities, among others, when determining what is in the corporation's best interests. And then this one has another end note, and it says see CalCorp Code Section 9241, contrast CalCorp Code Section 5231, which requires that directors exercise the care of an ordinarily prudent person in like position under similar circumstances and lacks a specific authorization to rely on religious authorities when determining what is in the best interest of the corporation. And, I looked at the statutes. I'm not going to read them here, but, the footnote does accurately describe the difference. And, I think it's an important one, right? Because, rely on competent religious authorities. Well, what's a competent religious authority? That would be David Miscavige, right? So, if he tells you, do this, then you're exercising that counts towards your exercise of the care of an ordinarily prudent person in like position under similar circumstances. Yeah, and it's specifically it's at section 9241, paragraph A, subparagraph 4. Religious authorities and ministers, priests, rabbis, or other persons whose position or duties in the religious organization the director believes justify reliance and confidence, and whom the director believes to be reliable and competent in the matters presented, so long as in any case the director acts in good faith after reasonable inquiry when the need thereof is indicated by the circumstances and without knowledge that would cause reliance to be unwarranted. So you can imagine that in the context of one of these high-level Scientology organizations, you could really drive a truck through that exception to the ordinary care rule. Okay, then the third point that the Napa Legal Institute makes is that directors of nonprofit religious corporations enjoy the protection of a more generous indemnification standard than applies to directors of nonprofit public benefit corporations. I don't think this one is particularly salient for our purposes, so we'll skip over that. But if I'm wrong, please correct me. Okay, returning to that list. It says 4, unlike nonprofit public benefit corporations, nonprofit religious corporations are not required to register with the California Attorney General or to comply with ongoing reporting requirement obligations to the California Attorney General, which strikes me as being potentially a big deal. So let's read the footnote. It says see Cal Government Code 1583, Cal Corporations Code 9212 through 9213, as well as sections 5212, 5213, and 6324. Note, however, that, and then it talks about how they still have to comply with some provisions of federal law. So let's break some of that down piece by piece. Section 6310. So this is part of the nonprofit religious corporation law. If any record subject to inspection pursuant to this chapter is not maintained in written form, a request for inspection is not complied with unless and until the corporation at its expense makes such record available in written form. For the purposes of this chapter, written or in writing also includes cathode ray tube and similar electronic communications methods. So they're referring to cathode ray tubes. So you can tell that this was written by old men in the early 1980s. I'm surprised they don't have a provision that's specifically dealing with telex machines, but that's the way it's written. So that's yeah, and then it goes on in section 9510. Each corporation shall keep adequate and correct books and records of account, minutes of proceedings of its members, board and committees of the board, a record of its members, giving their names and addresses, and the class of membership held by each. Blah, 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 blah. So, they've got to keep records. And then moving on to the next section, 9511. Again, this is part of the nonprofit religious corporation law that we're talking about. Except as otherwise provided in the articles or bylaws, a member, that word is going to become important, may inspect and copy the record of all the members' names, addresses, voting rights, etc. at a reasonable time upon 5 business days prior written demand upon the corporation for a purpose reasonably related to that member's interest as a member. But let's talk about members, right? Because in section 9132C, it talks about the articles of incorporation, right? So the articles of incorporation may set forth any or all of the following provisions. 1, the names and addresses of the persons appointed to act as initial directors, the classes of members, if any, and if there are 2 or more classes, the rights, privileges. So that's what I'm getting at. Classes of members, if any. So these organizations do not have to have members, and as we'll see, they don't have members. Anyway, yeah. So, and it also talks about how every director shall have the right at any reasonable time to inspect and copy all books, et cetera, et cetera. So the people who have rights to inspect these records that they're supposed to keep are members and directors, basically. They don't have to have any members. And that would be true of regular nonprofits as well. I looked at that. So I guess this isn't so much. No, Heather, right. So member is like a defined term, like individual Scientologists and Sea Org members are not like members of RTC. In fact, RTC has no members. It's kind of, the idea of members is kind of like a weird legal fiction. But the people who have a right to inspect and copy the books are members and directors, right? And we know that in Scientology, the way they treat directors is ridiculous. They have them, and multiple people have attested to this. Mike Rinder has talked about this. Jesse Prince has talked about this. Terry Gamboa has talked about this. Others have talked about it. So like, they have you sign undated, if you're like on the board of one of these high up Scientology organizations, if you're a director, they have you sign an undated resignation letter. So like, we can forget about the directors having rights to inspect these records, which they're probably not even keeping. And the members can't do anything because there are no members. Yeah, and I think that kind of segues well into, I want to read some portions of RTC's Articles of Incorporation. It's interesting, right? So the undersigned individuals, this is from 1981, this is their RTC's Articles of Incorporation. The undersigned individuals in each of them, namely Terry Gamboa, that's Janice Gillum Grady's sister, who has been out of Scientology for a long time. David Mayo, who shortly after he signed this document was persecuted by the church and formed a squirrel group, and they filed all kinds of lawsuits against him. Norman Starkey, who was the executor of LRH's will, I believe, and I think he got sent to the RPF for hitting on Brooke Shields at Tom Cruise's wedding. Phoebe Maurer, who's like a old school CMO person, I think. You hear her names come up sometimes. Lyman Spurlock Jr., who was basically an accountant within the Sea organization, who was kind of the mastermind behind the whole corporate sort out Julia Watson, I think that's David Mayo's wife, and David Miscavige, each of whom resides. So those are the people subscribing to the Articles of Incorporation and being incorporators of the corporation and initial trustees of the corporation. Having associated one with the other for the purposes of forming a non-profit religious corporation, blah, 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 blah. And then, where is it? Okay, so there's a couple of things that I think are interesting in these articles. Article 6 says the corporation's affairs shall be regulated and managed by a board of 7 natural persons who shall be designated trustees, which board shall have and exercise all powers given to directors by the California Nonprofit Corporation Law. And I wonder why they're designated as trustees rather than directors. Part of me thinks that this could be their lawyers engaging in some clever trickery that probably wouldn't hold up in court if it was ever challenged, right? Because it gives them all the powers of directors, but not all the rights of directors. And there might be a distinction there. Or there could be some other reason that I just is above my head or lost on me. But yeah, then at Article 8, it says this corporation shall have no members. So there's no members. Okay, and then section 9514, upon refusal of a lawful demand for inspection under this chapter, which, I mean, I guess it would have to be, for someone to make a lawful demand under this chapter, it would have to be a director who was coerced into signing an undated letter of resignation. Would have to be the person to bring the action, which is very unlikely that they could do that in a timely way. The Superior Court, blah, 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 may enforce the demand of the right of inspection with just and proper conditions, or may, for good cause shown, appoint inspectors or independent accountants to audit the financial statements. So I doubt that that's ever going to happen, but that's, something that people might want to be on the lookout for. If anyone who is a director of one of these organizations blows, and they contact a lawyer right away, someone might be able to look at all the books. Okay, I'm not going to go into detail about the analogous provision for regular public benefit corporations. It's long, the stream is already boring, but you can do that yourself if you're interested. Suffice it to say they're much more detailed. There's more required reports to directors and to members. Members and directors can more easily demand all kinds of records, including full lists of all the directors, minutes, accounting books, etc. But it's kind of a moot point, right? Because they don't have any minutes, and the directors are kind of neutered in a way that's probably unlawful with these undated resignations. Okay, so returning to the white paper from the Napa Legal Institute, and here it gets a little more interesting. 5, the California Attorney General's investigative powers with respect to nonprofit religious corporations are generally limited to criminal matters, whereas nonprofit public benefit corporations are subject to investigation at any time with respect to its internal affairs and compliance with its purposes. And this one has a footnote as well, which reads C Cal Corp 9230, Cal Corporations Code 9230A 5250, and Cal Government Code 12588. So let's start with California Corporations Code 5250. This is a statute applicable to public benefit corporations. That's regular nonprofits, basically, in California. And it's titled Examination by Attorney General. It reads as follows. A corporation is subject at all times to examination by the Attorney General on behalf of the state to ascertain the condition of its affairs, to what extent, if at all, It fails to comply with trusts, which has assumed or has departed from the purposes for which it is formed. In case of any such failure or departure, the Attorney General may institute, in the name of the state, the proceeding necessary to correct the noncompliance or departure. So that's pretty broad. Basically, if you're a nonprofit in California and you're not one of these religious nonprofits, the Attorney General at any time can just go in and say, "What's up? Show me the books. What are you doing?" And if you're on some bullshit, they can bring an action in court to um, do whatever's necessary to correct the noncompliance or departure. But if we look at Section 9230, which is the analogous provision applicable to nonprofit religious corporations, it says, except as the Attorney General is empowered to act in the enforcement of the criminal laws of the state. So unless there's some kind of criminal investigation going on, and except as the Attorney General is expressly empowered by subdivisions B, C, and D, the Attorney General shall have no powers with respect to any corporation incorporated or classified as a religious corporation under or pursuant to this code. And then sections B, C, and D are some like narrow exceptions. So basically, this law that the California Attorney General can go in and look at what a nonprofit organization is up to at any time does not apply to RTC, CSI, or CST. Okay, so then returning to the Napa Legal Institute's paper, it says 6, nonprofit public benefit corporations must have audited financial statements if they have $2 million or more in gross revenue. Nonprofit religious corporations are not subject to the same requirement. So I'm not going to look at the citations for that and read a bunch of boring text, but CSI, RTC, CST, at least under California law, do not have to have audited financial statements. Maybe they have audited financial statements pursuant to their deal with the IRS or for some other reason, but California is not going to make them do that. And then they talk about the limits relating to the California Fair Employment and Housing Act, which I don't think is particularly salient. Okay, and so that's it for the Napa Legal Institute's list. But there's something I wanted to talk about as well, a difference that I noticed. So if we look at section 6216, this is, again, this is a part of what's applicable to nonprofit religious corporations, including those Scientology organizations that I mentioned. It says, A, the Attorney General, upon complaint of a member, director, or officer that a corporation is failing to comply with the provisions of this chapter, Chapter 5, commencing with Section 5110, Chapter 6, commencing with 5610, or Chapter 13, may, in the name of the state of the people of California, send to the principal office of such corporation, or if there is no such office, so they can send notice of a complaint that, like, hey, you're not complying. And if the answer is not satisfactory, or if there is no answer within 30 days, the Attorney General may institute, maintain, or intervene in such suits, actions, or proceedings of any type in any court or tribunal of competent jurisdiction or before any administrative agency for such relief. Okay, I'm sorry. I said that this was part of the California nonprofit corporation law. This is not. This is what I'm reading now is applicable to regular nonprofits. This is at 6216. So if there's noncompliance, they can send a notice, and if there's not a satisfactory response to the notice, if you're a regular nonprofit, the Attorney General may institute, maintain, or intervene in such suits, actions, or proceedings of any type in any court or tribunal of competent jurisdiction or before any administrative agency. for such relief by way of injunction, the dissolution of entities, the appointment of receivers, or any other temporary, preliminary, provisional, or final remedies as may be appropriate. So including dissolution. So they can say, we're going to dissolve this organization. We're going to appoint receivers. That's a big deal. As may be appropriate to protect the rights of members or to undo the consequences of failure to comply with such requirements. And the requirements they're talking about are like reporting requirements and things like that. And it says B, the Attorney General may bring an action under subdivision A without having received a complaint and without first giving notice of a complaint. So it's pretty broad power. Okay, and then here's the one applicable to nonprofit religious corporations. This is section 9660. The provisions of chapter 12, so all of these provisions on required filings they have to make with the state and so forth, of part 2 apply to religious corporations except for section 6216. So except for the thing that says the Attorney General can do something about it if there's non-compliance and they don't satisfactorily answer a request for, like, to remedy the non-compliance, I guess. And then it says B, the Attorney General may bring an action in the proper county to compel compliance with Chapter 12 made applicable to religious corporations by this section. So the Attorney General can bring an action to compel compliance, but they don't have this broad power to get I guess they could get an injunction. That would be what you would have to do to compel compliance, but they can't appoint receivers. They can't say we're going to dissolve this organization. So it's really, they really don't have a lot of power to do anything if the nonprofit religious corporations filings are all fucked up. Napa, like Napa County, and it's important because Scientology's filings are all fucked up. There's they were behind on a lot of filings and had to get caught up to speed. And the real crazy thing is that I noticed is that, and I think Tony Ortega has also written about this, is that in CSI's most recent publicly available filing with the state, they still list Heber Jensch as the CEO of CSI in 2023. Heber Jensch is a very elderly sick man who's not functioning as the CEO of CSI. It's just a very fraudulent document, in my opinion. So that's it for the California nonprofit religious corporation law. I think I might do another one of these on the Religious Land Use and Institutionalized Persons Act, which I think is relevant to a lot of the stuff that's going on with the city of Clearwater right now. Thank you for tuning into this super boring live stream. But I think this is one where this is something that could be corrected, right? Other states don't have this. It's this ridiculous law that says that basically doesn't let the California Attorney General come in and look at the books just because they're a religious nonprofit. I think people talk about getting the tax exemption revoked and all of these things. That would be big fights, and this would be a big fight too. I imagine there are other powerful vested interests in keeping this, but I think perhaps this law could be tweaked if there was if someone had any connection to a California legislator who was amenable to hearing us out on it. I think particularly the part about how the California Attorney General cannot go in and check on the condition of an organization and their record keeping and all of that. except as part of a criminal investigation. I think um, if there was like a revenue cap on that, like if it was like, yeah, that applies unless you have more than $1 million in the bank. Um, that would be a quick fix that would maybe change this. So yeah, thanks for hanging out, and I'll see you all around.